So now we are getting an update from SIX Exchange Regulation. And I would like to welcome here on stage Michael Urwiller, Head Corporate Disclosure, and Deputy Head Matthias Weger. Welcome on stage.
Thank you.
So the floor is yours.
Thank you so much for the kind introduction. Good morning, ladies and gentlemen. We are the guys from SIX Exchange Regulation, so I hope your pulse rate is still fine and will not raise as much as Daniel Schmucki has experienced. Welcome to the annual update from SIX Exchange Regulation. As we have just a small window, I would like to start right away. Today, we present the following information to you. In a first short overview, I will explain the mandate of SIX Exchange Regulation and inform you about the status of the planned revision of the Financial Market Infrastructure Act and its impact on self-regulation. After that, my colleague, Matthias, will present the regulatory developments of this past year. So let's dive right into the topics. As you may know, the Financial Infrastructure Act governs the organization and operation of financial market infrastructures, as well as the rules of conduct for financial market participants. It aims to ensure the proper functioning and transparency of the markets, the stability of the financial system, the protection of financial market participants, and of course the equal treatment of investors. The stock exchange, as you can see on this slide, under the supervision of FINMA, ensures its own regulatory and supervisory organization that is appropriate for its own activities. Within SIX Group, SIX Exchange Regulation is responsible for the tasks of regulation and supervision. In terms of a recap, for you it should be noted that self-regulation consists of three different bodies: the regulatory board, SIX Exchange Regulation, and the judicial bodies. The regulatory board enacts the regulation or the regulations, is therefore the competent legislative element. Then the Sanctions Commission, the Appeals Board, and the Court of Arbitration form the judicative element. And as the third and executive body, SIX Exchange Regulation is responsible for monitoring, compliance with, and enforcing the regulations. So SER, SIX Exchange Regulation, imposes sanctions where the regulations grant this authority and submits sanction proposals. And FINMA is the supervisory authority and approves all the regulations before they come into force. As is well known, the Federal Council plans to, or let us now turn to the status of the FMIA revision, and this slide shows the current organization structure of SIX Exchange Regulation, the listing and enforcement unit. The self-regulated issuer obligations, as you may know, are colored in blue. And as is well known, the Federal Council plans to remove the two issuer obligations of ad hoc publicity and management transactions from self-regulation and to nationalize these obligations into state law. In addition, the obligation to maintain insider lists is to be introduced for all issuers. So where does this political business stand on the timeline? The FMIA has been in force since 2016. Already then, the Federal Council planned to review the law after 5 years, and in September 2023, it instructed the finance department to draft a revision. The consultation was held this summer in July 2024 and concluded just recently on the 11th of October. It is expected that the legislator will evaluate all the reports next summer in 2025 and refer then the matter to Parliament. If the proposed law finds majorities, a possible enactment can be expected in 2027-2028. And now let's move to the second block of information concerning the regulatory developments of this year. And for that, it's my pleasure to hand over to my colleague, Matthias.
Thank you. Thank you, Michael. Thank you very much. Warm welcome also from my side. We've seen, Michael has shown us uncertain times ahead. Despite that, the regulatory board is still committed to improve and amend regulation in order to best fit market needs. So 2024, just like 2023, has been a year marked by quite a few changes, introduction of new set of rules, introduction of new single obligation, but luckily for you also some deletion. Let's start with the changes to the ad hoc publicity. The introduced per se price-sensitive facts regulation have been amended slightly. As you are all aware, the obligation foresees that issuers are obliged to publish annual and interim reports with an ad hoc announcement in any cases. Now, this rule has been shifted from the directive on to the listing rules, which is a formality and has no real impact to the practice of the issuers. However, what does have an impact is that the scope of applicability of that provision has been limited. The per se qualification now only exists for issuers of primary listed equity securities. This does not mean that issuers of derivatives, for example, do not have an obligation to publish annual or interim reports via ad hoc announcement. It simply means that they will have to evaluate on a case-by-case situation whether this information is price sensitive or not. Also, as announced at last year's presentation, those of you who already joined last year's conference will remember we had some significant changes to the regulation on management transaction, which entered into force in February 2024. By that, we introduced a new reporting obligation concerning transaction between persons subject to the reporting obligation, being members of the board or of the management, contracting in transaction with related parties. These transactions will have to be published and reported, and will also have to be described in nature in order to guarantee transparency. The exception, however, to not report transactions if they are not rooted into an investment decision still applies also for that transactions. However, if any subsequent transaction arising out of that transaction by the related party will be concluded, these transactions will have to be disclosed as well. For the rest, we had some minor changes which have minimal to quite a little impact to issuers. Setup, we moved some directly, or the regulatory moved some directive from the some regulation from the directive to the listing rules and specified within the directive already standing in the existing practice followed by most of us and well established. For example, the obligation to report transaction in listed and unlisted security if at least one of the equities are listed, the prohibition of netting, and the obligation to correct errors. All these are, of course, already existing practice. They have now just been however specified also in the directive. If you would like to learn more about these topics, I kindly invite you to go on our website. There is a more detailed recap of what changed, but also new guidelines available, which I'm pretty sure will answer a lot of your questions. Crypto remains a topic, gains importance within the financial market, so it has also impact on our business. We actually amended various regulation and introduced a new directive on crypto assets as underlying instruments, hereby kind of defining more precisely which kind of crypto assets may qualify as underlying instruments for derivatives or ETPs. By adopting these new rules, we can now say, and probably nowadays seeing the rise in prices again in the crypto industry, the number will also be increased, but we now see approximately 100 or likely more than 100 cryptocurrencies which could be now potentially be used as underlyings. We cleared the question regarding the collateralization of those instruments by clarifying that an analog logic as applying to structured products will be in place. We adapted disclosure obligation within the prospectus, and we explicitly added the possibility to suspend or terminate the listing of those products due to changed market conditions. Another change, which is not really strictly regular from a regular point of view, but surely impacts most of issuers' life, are changes to the disclosure of shareholding setup. We introduced in March 2024 a new platform, OLS Digital, which had the aim to simplify the reporting process, now allowing investor to submit directly the notification online. Again, also here we have plenty of documents explaining the tool if there is any interest. And another quite big revision we had concerns the regular reporting obligations. A completely new directive has been launched and entered into force on the 1st of September. The aim was to simplify and streamline the reporting obligation and to clarify the structure of the documents. Therefore, we had some deletion, but also some new additions in terms of obligation. For GDR issuers, the obligation to notify recognized representation in Switzerland. And for all the issuer, the obligation to report the creation or the cancellation of reserve capital and convertible capital, as well as change in the capital band. But luckily, there have been also some deletions of provisions which didn't fit market requirements anymore, like the need to report the address of delivery for legal documents, no need to report changes in business activities or in investment policies for investment or real estate companies, and the need to report resolution on restriction on transferability for issuers with listed registered shares. So you've seen we have had a lot of changes, some of them more prominent, other less. We, despite the uncertain times ahead and the regulatory is still committed to continue to develop our regulation. And with that being said, I hope that this was a quick and helpful overview, and I thank you for your attention. Thanks a lot.